Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. Today is May 18th, 2017. This is our bi-weekly community conference call every other Thursday. As usual, I'll be going over the posted questions only. I will not have time for new questions. Unless your question relates to a topic under discussion, I will not be able to deal with it today. I'll do the frequently asked questions first. There are certain questions I have marked as frequently asked questions, and then we'll deal with the regular questions. I'm monitoring my Twitter feed. If you tweet to me, I will get it, but no new questions, please. Excuse me. Okay, so let's get started. My first frequently asked question is from Arunava Chakravarti, who says, is it legal to work for a foreign-based company in the USA? So this scenario comes up quite frequently, and that's why I had marked it as a frequently asked question. The scenario is, you are in the United States on a non-work visa, F2 visa, H4 visa, any kind of non-work visa. But your employer is in India or Europe, outside USA, and they want you to continue working. They'll keep paying your salary or your contract amount outside USA. The work that is being performed has nothing to do with the United States. Can you still work in the USA? I have been advising people not to, because I feel that government can take the position even if there is any kind of a tangential or a far-fetched connection with the United States of this business activity or work activity. They could come at you saying this is a violation of your status. Now remember, violation of status is not the end of the world. You can always go get a visa stamping for most of these cases, and that takes care of your being out of status. But it's something I would like you to avoid if possible. So in my view, if your wife has come here on L2 visa and she wants to continue working, I would wait till her EAD, because I just don't like to have that gray area. I would not want her to continue getting her paychecks. I'm a little leery of this situation. I've had other colleagues of mine say that if the business for which she's working has nothing to do with USA, they have no clients in USA, they are receiving no money from USA, they are not channeling any money through the USA, then it's okay to work for this company in USA while you are getting paid abroad. I have my doubts, so my advice would be not to. *5 if you have a follow-up question on this. Press *5 on your phone if you have a follow-up question on this. Okay, let me go on to the next frequently asked question, which is actually, I have combined 3 different questions into one because they were all related. One was from Ashok K, another one was from Pete, and another one from Nick_H1B. I combined all these questions into one because I thought they are all related and they're all part of a frequently asked question pattern. So what is this pattern? They're talking about changing employers after I-140 is approved. What impact does it have on H1, green card, H4 EAD, etc.? Let me discuss with you first the general law, and then we'll look at these questions in particular. Now this might be relevant to a lot of people, so you may want to, if you want to, you can take notes, or you can of course wait for the recording to come up. First of all, the moment your I-140 is approved, no matter which category, EB1, EB2, EB3, the moment it is approved, the priority date is yours to keep. That means if you got your green card filed in, let's say, 2017, and you left this employer after the I-140 approval, they revoked your I-140, and you started another green card in 2020, your priority date will be still 2017 because your I-140 was approved. So the moment the I-140 was approved, the priority date becomes your property, and it can be carried across categories, across employers, across geographical areas. So if you go from a perm filing in New York to an employer in California and your previous filing was EB3, next filing is EB2 or even EB1, you can carry the date of the old petition as long as the I-140 was approved. So takeaway is, the moment the I-140 is approved, the priority date is yours. There are limited exceptions unless the I-140 is revoked for fraud, etc. by the USCIS. Even if the employer revokes the I-140, you will keep your priority date. In addition to that, if the I-140 gets approved and stays approved for 180 days, you will not only carry your priority date, you will carry your right to extend your H1 through any employer indefinitely. Okay, so you will get a second benefit after 180 days, and if the old employer revokes the I-140, you will still get the benefit of both priority date and the right to extend your H1 through any employer. Government has also said, if you have an H4 EAD for your spouse and your I-140 stayed approved for 180 days, your wife's or your husband's H4 EAD is safe even if the old employer revokes the I-140 later on, as long as the I-140 stayed approved for 180 days. So if you left, but the I-140 stayed approved for 180 days, H4 EAD is safe. That in a nutshell is the general law. Let me look at the specific questions. Ashok wants to know, my priority date is 2014 EB2. I'm on my 5th year of H1 extension is currently going on. I have a tweet. Let me just check my... Okay, that's just a follower. Okay, so my plan is to change my employer once my extension is approved, but I have the following questions. I'm 100% sure my employer is going to withdraw my I-140. How is my H1 transfer going to work? And I gave you the answer that if the I-140 stays approved for 180 days, great. If it does not, then make sure at least that you have an unrevoked I-140 till the H1 is approved, because the H1 transfer will probably be for about 3 years. Just make sure that you don't get the I-140 revoked, so stay with the old employer. Next question is, does the new employer have to file a new labor, etc.? And the answer is yes. The employer will have to start your green card all over again, but you will carry your priority date. The only time you don't have to file a green card all over again is if your 485 has been pending 180 days. That's called AC21 portability. Wife is on H4 EAD. She applied for her extension. What happens if the employer withdraws I-140? I just answered that question. If the I-140 stayed approved for 180 days, subsequent withdrawal by the employer will not affect your wife's H4 EAD. Can she continue to work with her new H4 EAD? Yes. Can I immediately start working for my new employer upon receipt? Yes. But the reason I would have you're a little early in raising your hand, stand by. I'm still reading the facts and the questions. Can I immediately start? Okay, can I work for a company which does not e-verify? Yes. Yes. Yes, I don't see any problem with that. E-verify is needed for mostly for, I'm trying to remember, STEM OPT extension, but e-verify by itself doesn't give you any benefit or disadvantage in green card or H1. My visa is going to expire in September 2017. Will I need new visa stamping after September? Yes, of course. But not unless you are traveling. So chances are if you get your extension and transfer within the USA, you won't need a new visa until you travel. Visa is required only when you go outside USA and you want to come in. I'm also sure they are going to withdraw my H1. That doesn't matter. Can I stay here? In USA, yes. Once you file your H1 transfer, it's received by the USCIS and you leave the old employer and they withdraw your H1, no problem. You can stay in USA because you have a timely filed pending case. Can my new employer file I-140 and 45 concurrently? No, not unless the priority date is current. With current trend, should I go for EB2 or EB3? You should always go for EB2 because it is allowed under the law even though you're entitled to EB2 to ask for EB3. The other way is not correct. Okay. Then there was from Pete, there were some questions that were related. Pete said, I'm on H1B, I-94 is expiring on December 2017, I-140 approved 6 months back from employer A, planning to change employers by transferring H1 for a permanent position. Can we file 6 months prior to expiry and also premium processing? Option not available. Okay, so question number 1, should I wait till July 2017 for employer B to file H1 transfer along with extension, or go ahead and file extension with employer A? Why can't you do both? Why can't you do both? You can do extension with employer A and transfer to employer B both at the same time. And you can even choose which one you want to go with if both are approved. And the last merged post is from Nick H1B. I haven't heard Sergi for a while. I have I-140, he says, hi Sergi, I have I-140 approved since 4 years with employer A. I want to join employer B. Can I join employer B once LCA is approved? No. H1B application received by USCIS? Some doubt about that. Excuse me. Excuse me. Some readings of the statute suggest that you can join the new employer as soon as USCIS received your H1 transfer. Another set of thought says you should wait till you get the physical receipt. So that's still up in the air. But definitely you can join upon receipt, getting the H1B receipt. I have 2 hands up already. If you have follow-up questions on these scenarios, press *5. Those with the hands up, keep them the way they are. Because this is a toggle. If you press it again, it will go away. 4 hands up. 5 people have follow-up questions. Please don't ask me any new questions, only follow-up questions on this. So let us begin first with 6 people follow-up questions. With California. California, go ahead please, we can hear you. California.
Hello Rajesh sir. So this is a follow-up question with I-140 that is being approved and it's already 6 months over. So my question is my husband is planning to apply for an extension for H1 because his I-140 is approved and completed 6 months. I'm working on H4 EAD. Say if his H1 extension papers doesn't come up quickly, can I still continue to work, sir?
No. If there is a gap between your old H4 EAD expiration and the new approval, and your H4 was timely filed for extension, you can stay in the United States, but you cannot work. You cannot work.
Oh.
Now the law is different for EADs that come through 485. EADs that come through 485 would allow you to continue working for up to 180 days while the old one expires and the new one is still pending. But H4 EAD does not enjoy that privilege. Okay?
Okay, sir. Thank you.
You're welcome. Let's go on. We have 5 more people with questions that are follow-ups. So let's go to California again. California, go ahead.
Yeah, and one of your replies is that you were talking about AC21 portability. Can you elaborate on that?
Sure.
What does it mean?
Sure. See, remember, there are three different kinds of portabilities we are talking about. Two are actually called AC-21 portability, one for green card, one for H1. AC-21 portability that applies to H1 is simply this: if you are currently maintaining H1 status and you file an H1 transfer for another employer, you can start working with them upon receipt. That's H1 AC-21 portability. Okay so far?
Yes.
Let me go on to the question you asked, which is AC-21 green card portability. But before I do that, I want to go back to priority date portability, which is also something I discussed. Once I-140 is approved, your priority date can be taken to any other employer, even though they have to start the green card all over again. The advantage of taking priority date over is that you can have totally different jobs, EB2 to EB3, EB3 to EB1, doesn't matter. Priority date can go to any case, any employer, any job, anywhere. Clear so far?
Yes.
Now the question that you asked, AC-21 portability of green card. AC-21 portability of green card applies where I-140 is approved and I-485 has been pending 180 days. Once that happens, you can change employers and go to any employer with the same or similar job. Now, there is a restriction here. Remember, when you port priority date, you don't have to have same or similar job. But when you port green card, you have to have same or similar job. As to what is same or similar is a very long discussion. And by the way, AC-21 stands for an act, American Competitiveness in the 21st Century Act, which made these provisions possible. Clear?
Yes.
Anything else?
Yes, I have another question.
Go ahead.
You were saying about EB2 to EB3. Can I, with the current plan, should I go for EB2 or EB3? I mean, what I was basically going to ask was, with so many applications these days getting filed in EB2, EB3 seemed to be a better option, right? I mean,
No, but you realize we've done this before, and I think that is still the case. Let's say you get your green card approved under the master's degree EB2 category, but when you file the I-140, you ask for EB3. That's fine, you can do that. But if, on the other hand, you have filed your perm application for bachelor's with 3 years experience or 4 years experience, you are stuck with EB3. So if you have an EB2, you can step down to EB3, but if you have an EB3, you cannot step up to EB2. Okay?
Okay, got it. Thank you.
You're welcome. Good luck. Okay, now we have actually 6 more people with follow-up questions. So let's try to keep answering questions. This one is from Ohio. Ohio, please go ahead.
Hi. So the question is, I have my I-140 and I-485 pending for more than 5 years. And if I do AC-21 with my new employer, does my new employer have to file I-140 if my prior employer revokes I-140?
No, ma'am. That is the whole advantage of AC-21 green card portability. If your jobs are same or similar, you don't have to have anything done through the new employer except, write this down, have them sign off on your supplement J, J as in John. That's a new form which a transferring employer of a green card, AC-21 green card, has to sign. Not a difficult form, simple form. Take a look at that form. The new employer will have to sign supplement J.
Along with AC-21?
AC-21 is covered under supplement J. Basically, you just file supplement J and that means AC-21.
Gotcha. Okay.
There isn't any, it's not a difficult process. Basically, supplement J simply is a way of giving a job offer. The new employer is giving a job offer on supplement J, and the supplement J demonstrates it to be same or similar job. That's the idea.
Okay. So once my new employer signs that and submits that form, supplement J, can I start or do I have to wait until the processing is complete?
You can start even before you file supplement J.
Oh, okay.
Okay.
So, and one more thing, like, what if, like, when I'm very close to getting my green card back. So, what if, when it opens and I change my employer, and for some reason, with all the new rules coming in, what if my prior employer, they find out like there was some fraud happened with the prior employer?
Oh, that can be a problem. Fraud is one thing that can hurt you. As long as there is no fraud, mere revocation of an I-140 has no effect on an AC-21 green card applicant.
Okay. So the thing that I'm asking, if I'm already with the new employer, can that fraud thing impact to me if it happens to the prior employer?
It can, because then they could revoke your I-140 because it was approved based upon fraud. It's a very complicated question with a very complicated answer. And unfortunately, we've done just too many of them to tell you that this is not a simple situation. If that happens, you need to contact us or some other lawyer who has done this before and feel comfortable with that kind of a situation. But yeah, and if you are uncomfortable with that and you have some reason to believe that this old employer has been up to some shenanigans, just start a new green card through the new employer, port over on AC-21, start a new green card, so you can move over to the new green card if something happens to the old one.
Okay, and my priority still remains the same.
No,
Is that correct?
not if they revoke it for fraud. No.
Oh, gotcha. Okay.
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 Good luck.
Okay.
All right, bye-bye.
Yeah. Thank you.
You're welcome. Okay, so we've got 6 more questions. Let's go on to the next. I knew this was going to be a very often confronted topic, more than a frequently asked question. This one is from Pennsylvania. Pennsylvania, go ahead, please.
Hey Rajiv, good afternoon.
Good afternoon.
I have a question. I have 140 approved from employer A and 180 days over. In this situation, if I change to a new employer B and after getting my H1 receipt, H1 transfer, I can start work, right?
Yes, sir. You can.
Okay. For some reason, after starting, and if my petition is still pending, say like more than 6 months, and then like I don't know, like whether it's like 280 days or something. If it is not pending, my petition is still pending. So after crossing like 280 days or something, do I need to leave US?
No. Hang on. Let's split this up. Okay. There's a little bit of a doubt that I would have to clarify. I have to look at the law. See, we do this as we confront these situations. I haven't had to confront this situation, so I haven't dealt with it. But let's say, first of all, understand what that 240-day rule is. That rule is, if you timely file an extension with an employer that you're working with, you can continue working even after the current status expires up to 240 days, about almost 8 months. Okay. But that's for an extension. Does it apply to transfers? I don't think it does. What applies to transfer is AC-21 portability. That's H1 portability. There is no limit of 240 days on that. So what if your case is not approved for 1 year? Can you continue working? I'm a little fuzzy on that. I'll have to double check the law. I think you can, but don't take my word for it. I'm just making you aware of all these wrinkles in the law, that if you apply for an extension with the same employer, the rules could be different. If you apply under AC-21 portability of the H1, the rules could be different. What is AC-21 portability of H1? It simply means your previous H1 is still going on, you filed an H1 transfer and you joined the new employer upon receipt. That's AC-21 portability. So the law on how long you can continue working there is a little different. I think there should be no limit on that. Okay, but if we do the research and we find that there is a limit, I think that is a ground for asking for expedite. Remember, premium processing is not available, but expedite is still available.
Okay, so even if I have 140 approved and 180 days is also crossed, even in this situation also like 240 days is kind of a question as of now.
Yeah, I think it is indefinite. I think you can continue working as long as the case is pending. But here's another situation. One more thing I want to add. One thing is quite clear. Once you have an H1 timely filed, whether it's an extension or a transfer or an amendment, you can stay in the United States as long as the case is pending. Whether or
Okay, Rajiv, thank you very much.
whether or not you can work, that's something we'll have to toss around, because I think that requires a little bit more of a fine tuning. I can't really answer that question definitively right now. Okay?
Okay, Rajiv, thank you very much.
Oh, you're welcome, sir. For some reason, I think we keep getting back to that number 6. Okay, let's go on to the next one. This one is from Georgia. Georgia, go ahead, please.
So my question is that I recently moved to a new employer under the 365-day rule, which means that my PERM was applied by my previous employer, while my 140 was not approved, and I decided to move to a new employer. And now my previous employer has canceled my PERM application. Now my question is on the EAD, that can the H4 EAD, is my wife still eligible for H4 EAD in this case?
USCIS has said if there is no I-140 approval at all, not even one, and we have already given you the H4 EAD, we reserve the right to revoke it. They may never do it, but they reserve the right to revoke the. So until they revoke it, she can continue using it, but she won't be able to get an extension on that. Okay?
Okay.
Good?
Got it. So we haven't applied for H4 EAD yet.
Then you
but
won't
I
be able
want
to.
my-
You won't be able to apply because there is no I-140 surviving.
Got it. Got
Okay.
it. Okay.
Now, one thing though.
Okay, thank you.
One thing. You did say I-140 was not approved, right?
That's correct.
Yeah. So you can never apply for an H4 EAD anyway without I-140 approval. So, okay.
Okay.
All right.
Got it.
Good luck.
Thank you.
All right, bye-bye. Okay, we have 4 more. So let's go on to the next one. This one is from New York. New York, go ahead, please.
Yeah, hi, Rajiv ji. The question is, I have an I-140 EB1 approved, and my I-485 has been pending for about 14 months now, and I got an RFE request because the medical examination now requires a gonorrhea test. So
Right.
I have to send it off. But the thing is, I just noticed that the priority dates, which were current for all categories,
Right.
India and China have moved to 2012.
Right.
So will that affect my I-485? It's now in the
Well,
RFP stage.
They are probably not going to be able to approve your case until the priority dates become current. But I'm not sure that this EB1 backlog is going to last for long. We'll see what happens over the next couple of months. I think this is a blip on the screen and probably will go away. Okay?
Okay. Now, if I send the RSE, the medical examination, usually how long does it take for them? So before May, let's say they try and review my application again after I send the RFE before June 1st, it should be fine, right? Only after June 1st it's going to be.
Yes,
not going to be,
that's a very good point, because the retrogression begins from June 1st, and if by some hook or crook you get the response into them early enough and they get working on it early enough, what happens is once your 485 is adjudicated, the adjudications officer requests a number, a visa number, okay?
Right.
And they do it either by email or by fax. If they receive the visa number, even if they receive it 3 days after June 1st, they can approve your green card.
Right.
They can approve your green card.
I see. How long is it usually taking when you send the RSP for I-485? Like a simple RSP?
I don't think there is a limit on that. It depends upon how busy the officer is.
Okay.
Okay. Good
Okay,
luck.
Thank you very much. sir.
You're welcome. Good
Thank
luck. Good luck. Okay. We have 3 more. So let's go to the next one. And this one is also from New York. New York, go ahead, please. New York?
Hello.
Yes, ma'am. Go ahead.
Yeah, hi, sir. So my question is regarding my husband's H1B visa status. So he has H1B visa till Jan 2020 with employer A.
Okay.
But he recently shifted to employer B and has valid H1B petition.
Okay.
So if he has plans to travel to India, can he come back with the existing H1B visa which is from his previous employer, or does he have to go for stamping?
In my opinion, he can come back with the same visa. USCIS, not USCIS, consulate tried to tell me, no, you have to apply for a new visa. I showed them a paragraph from their own standard operating procedures which clearly says you can use the same visa. So then they backed off. So my opinion is, yes, you can use the same visa. Okay?
Okay, so is there, are there any, sort of questions that we can expect in case if they ask regarding his visa status and all?
Not any more or different from somebody who was coming with a visa approval from the same employer. So I don't think there is any extraordinary questioning just because you are using visa of employer X traveling on approval from employer Y. Okay?
Okay, thank you so much. I also have another question.
Okay.
So this is regarding my status. I'm also currently on H1, but I would like to convert my status from H1 to H4. So, if I heard that if I go back to my home country, just India, I don't have to file the 539 form. I can just take an appointment with the US consulate and get my stamping done and come back and apply H4 EAD. Is this correct, or do I have
that is correct, ma'am. H4, unlike H1, does not require approval from USCIS first. So if your husband's H1 is approved, you could walk into any consulate and get an H4 done. Okay?
Okay, yeah. So as long as I'm in this country, I have to apply 539 form, right?
You do not have to apply I-539. No, ma'am.
Then how do I get that H4, petition?
Based upon your husband's H1 approval.
Oh,
So when
so I don't have to-
you show his H1 approval, your marriage certificate, your passport, you are entitled to H4.
Okay, yeah, I got that, but I'm saying, what if I'm not willing to go to India, for some reason? I want to stay in this same country.
Then you have to apply
And
for I-539. Yes, ma'am.
Oh, okay,
Okay.
yeah, got it, yeah. Thank you so much, sir.
You're welcome. You're welcome. Okay, next question. We have 2 more in this series of questions. Let's see. This one is also from California. California, go ahead, please.
Hi, Raju, sir. So, if we apply for the extension, my visa I-94 is expiring on the December, and so 6 months is, I think I can apply in June for the extension. And given the scenario, it's taking 8 months. So if my current client, the project ends while the extension application is going on, do we have to, I have to choose a different client. So how does that work? Can we have two cases?
What happens is if you are working on project number 1 and your H1 amendment or transfer or extension is pending, and while it is still pending, you run out of that project and you go into project number 2, while the first case is still pending, your employer will file a second case for H1 amendment, and as long as the first case is approvable, the second case should also be approved. So yeah, even while the first case is pending, you can file a second, third or fourth case. Okay.
Okay. So will will the denial of case 1 affect the case 2 as well?
Worst case
The way you are saying-
scenario, if the first case is denied but the second is approved, you might have to go outside USA for visa stamping, but it does not affect the merits of the second case.
Okay.
All right.
Okay, sir.
Good luck.
Thank you.
Let's go on to the last question in this series, which is from California. California, go ahead, please.
Yeah. So I have two follow-up questions. One of them will be a frequently asked, so sorry about it.
No problem.
The first question is an extension to the fraud discussion that we just had. So let's say if old employer commits fraud, the employee moves to a new company, will he still be affected? He or she will be still affected by whatever fraud the old employer has done?
He can be. There are a few different scenarios. I'm assuming that the employee was not complicit or participating in the fraud. That is a given. So if the employee was not participating in the fraud, the most important thing would be, did the employer's fraud touch the I-140? For instance, let's say the employer was cheating on his taxes. That has really not that much of a relationship with an I-140, especially if you were getting paid the full amount of money. So I think in those cases, we can very well argue that fraud has nothing to do with your I-140 approval. But where the employer committed fraud in the I-140 itself, you will be affected. They'll take away your I-140.
So if the employer has, say, X number of employees, and if one of the employee and the employer have committed fraud, all the other employees will also get affected?
Not necessarily. Not necessarily. It depends upon how pervasive or problematic the fraud is. We've had cases where I had a series of cases, I think a couple of years ago, where 64 or 65 cases got denied, revoked. And when we fought it, we were able to reinstate 63 of them. We lost one simply because that was an education problem. But we were able to walk away from any implication of fraud. Government is very quick sometimes in throwing fraud. Oh, fraud, fraud, fraud. See, it's like a mantra. It's easy to say. But if it really is not something easy to establish in most cases. So what I'm saying is it depends upon the facts of each case. One employee's fraud does not necessarily implicate all. It depends upon the facts of the case.
Okay. The second question I had was, can H4 spouse travel between H1 transfers?
Yes. As long as the H4 spouse has a visa and still valid, your H1 transfer does not affect her travel ability. In fact, even you can travel between H1 transfers or extensions. You cannot travel between change of status. So if you are converting from F1 to H1, travel means you'll have to get a visa to come back in. But if you are applying from H1 to H1 transfer or extension or amendment and your visa is still good, you can also travel, and spouse can certainly travel, no problem.
So she can come back with an existing visa before the visa expires with a new H1 transfer or whatever, right?
That is correct.
Okay, thank you.
You're welcome. Okay, so the last question in this series of questions is also from California. California, go ahead, please.
Hello, sir. Actually, I had one question related to I-140. Say employer A has applied I-140 and it is approved, and now new employer B initiates a green card, but employer A doesn't revoke the I-140. So in this case, both are active, sir?
Yes. We've had cases where multiple I-140 were active, and they remain active forever. Not 1 or 2 or 10 years. They remain active forever. You can use any one of those I-140s as long as the job is available.
Okay, sir.
Okay?
Thank you.
You're welcome. Good luck. Okay, guys, this took a lot of time. So I wasn't expecting to spend so much time on this, but sometimes that's how it goes. Let's go to Dr. Acharya about a physician's NIW, AC-21 portability, teaching to clinical position. I'm not sure I have clean answers to these questions. I've not run into these situations very frequently. Our cases tend to be straightforward. We also plan well. So first of all, do the 3 years spent in residency training in an HPSA MUA area, can they be counted towards 5 years requirement? 3 years spent in residency training. I don't remember this. Typically the scenario that we deal with is where somebody had a J1 while they were doing their residency. We got the waiver. Let's say it was a Conrad 30 waiver. We got them started to work, and those 3 years can be counted towards NIW 5 years. I doubt very much. I don't know the answer to this question, Doc. I'll have to hit the books for this one. I don't know what the regulations require for these cases. So my apologies, don't know the answer off the top of my head. And by the way, when you are dealing with HIPSA, MUA, all these different areas, usually you can take the benefit accrued in one area to another area. In fact, we've had cases where somebody did part of their national interest waiver in a HIPSA or a medically underserved area, and some of it in a Veterans Administration. We could combine those two. There was provision for that. It's not written down anywhere, but they let you do that. I'm not sure, can the NIW petition be filed now retrospectively? And I think there's a limit to how long you can use, like within X number of years, you have to complete your 5 years. It isn't indefinite. In fact, there was a whole litigation about it, if I remember correctly. But I don't know the answer to this one either. I can give you some hints, but somebody's going to have to hit the books. Last question is now, if I am designated an assistant professor and I got my green card, but I'm going into a clinical position with only patient care and no teaching, can this be considered to be a same or similar job for AC-21 purposes? Very difficult question to answer. My guess would be yes. But I'll tell you what makes me a little uncomfortable with this situation. USCIS, in defining same or similar, gave an example, and I'm trying to remember if I'm quoting this example correctly. They said, if you have a restaurant in which you have a chef, was it a chef? Or a cook, you have a cook, and you want to promote them to food and beverage manager, we don't consider that to be same or similar job, because one didn't have anything to do with that. I think something like that. So the idea is that if the jobs are to be same or similar under AC-21 portability, they have to have characteristics where working at one qualifies you to work at the other. So there is a connection between the two. In the teaching and clinical, there is really no connection. But you could talk about the fact that when I was an assistant professor, I also was treating patients. That's a part of my job. So it's a difficult question to pin down an answer. I guess you'll be okay, but I cannot guarantee it. One good thing though, like you are a doctor, it's your job to find solutions, not to debate just the possibilities. My solution to your situation is very simple. Under the current regulations, beginning January 17th, you can actually ask for a predetermination before you change jobs. You can send your supplement J and wait for the government to decide it before you join the new employer. So they will actually pre-adjudicate the case so you know you are safe when you move instead of just jumping. Star 5 if you have a follow-up question on this. Star 5. Next frequently asked question is from New Andhra about impact of a misdemeanor under Trump executive order. The law is still the same as far as I know. There is no change if you are legally in the United States. If you are illegal, things would be different. If you are undocumented, things would be different. But if you are in a legal status in the United States and you get convicted of one misdemeanor, you are still covered and exempted by petty offense exception. Petty as in small, P-E-T-T-Y, offense exception. You can Google that. That doesn't change. Star 5 if you have a follow-up question. Okay. Folks, I just want to make you aware, I see that a bunch of people have just joined. I'll not be able to take new questions, only follow-ups. We have no time for new questions today. In fact, even I'll be hard pressed to even finish the ones that we have posted. Mr. Sagar Shah says, extending H1 H4 EAD working while extension is pending. We discussed that in detail in an earlier question. So I am on H1, wife is on H4, EAD expires on July 18th. I'll be completing my 6 years by July 18th. I-140 is approved. Should I file for H4 EAD extension along with my H1 and H4? Yes, you should. Can she work while the extension is in progress? No. Once the current H4 expires and EAD expires and you are waiting for the new EAD to arrive, she has to stop working. Star 5 if you have a follow-up question. Star 5. Okay. Let's go on to the next frequently asked question from Ramaya. Multiple green cards. Can we file multiple green cards together? The answer is yes. You can file green cards through as many categories as you want to, both employment as well as a mixture of employment and family or investment. Any number of green cards can be filed as long as they are being filed honestly. Good faith. Can we file multiple green cards together? What will be the side effect? As long as it's honestly done, no side effect. My company filed my green card in EB2, 2013 priority date, approval is here. I want to try EB1. I don't see why not. Should job description match EB1 and EB2? It doesn't have to. What all possible issues may occur? That's something, it's like asking somebody to write a book. When I ask a doctor how many diseases can there be, it's a very difficult question for them to answer. It all depends upon the facts of each case, but at least theoretically it's possible. Star 5 if you have a follow-up question. Last frequently asked question of the day is, what can I do if I have an H4 EAD? The answer is anything you like. You can work, you can choose not to work, you can start your own business, you can work 3 hours a day, you can work 10 hours a day, you can work 18 hours a day. Anything you like. Can H4 EAD person open a small business like an ice cream shop part-time? Sure. Can H1B spouse support the maintenance of the business? I am a little uncomfortable with that. So if you see, normally if you don't get money, it should not be a problem as a volunteer activity. But here there are two problems. One problem is the ice cream business is a for-profit business under Fair Labor Standards Act. They cannot take free work. And two, this might be a violation of your status because it is giving you a benefit, directly or indirectly. I think it's a little difficult situation. She can do what she wants. You shouldn't work for her. Star 5 if there's a follow-up question. Okay, I'm going to get started on the normal questions now. So the first non-frequently asked question, Pankaj says, I hope you are doing great. Yes, sir, I am. I hope you are doing great as well. I have a question regarding EAD. My wife moved to H1B from J1 on Jan 1st. I moved to H4 from J2. My wife filed for green card under EB1B outstanding researcher category October 2016. She filed I-140, 45 together. We've got EADs. I used my EAD to work starting Jan 2017. My wife didn't use her EAD. So do you think by using I-485 EAD, H4 is invalid? Yes. Yes. From the date I started using my EAD, yes. If my 485 is denied, do I have to leave the country immediately? Yes. You just go get H4 visa stamping and come back. Because she's still on H1B, so you can just go outside USA. If you already have an H4 stamp, you just need to step out and come back in. If you don't have a stamp, you go get an H4 visa and come back. Simple. Star 5 if you have a follow-up question. TQNK has a question about G4, International Organization. So the question is, I come on G4 occasionally. Can my child go to school in a high school while on G4? I don't know, ma'am. So far, what we have done with these cases is get them an I-20 from school. So in other words, convert them to F1 status, and of course you have to pay for the education. So F1 would be the better way to do it, but I also want you to be aware that not all high schools would know what I-20 is, far less being approved to issue I-20s. Be aware of that. Okay? So, but F1 would be the way to go. Star 5 if you have a follow-up question. So, what if I change my citizenship? I have a green card. I was a Indian citizen. Now I've got Canadian citizenship. What do I do? Well, you travel with your green card and you can travel with both citizenship, both passports. I don't know of any way you can update the government on this. This is perfectly legal. What you can do is, now the only problem is, wait, I just thought of something. I think India doesn't allow you to be a dual citizen, right? So you have to surrender your Indian passport. It will be a good idea. I don't know the answer to this question, April. I think it will be a good idea to contact USCIS as well as Customs and Border Protection. Ask them what they suggest. I think you should be able to travel with just your Canadian passport and your green card. That's what I think. But let's just double check and make sure. This is not a legal problem. This is only a logistical problem. So don't worry about it being damaging to you. It's only a question of how to have the least trouble at the border. Contact both CBP and USCIS. Star 5 if you have a follow-up question, guys. Okay. Once again, I remind people I won't be able to do follow-up questions. We'll run out of time. New questions. Next question is from Ox341. Job on H1B ended in March. Found another job during grace period. Started working. H1B employer is a staffing company. One of the top 100 H1B users. Client is a $5 billion plus public company. I have an H1B visa stamped until 2019. And the 797 approval of last employer good till July 2019. If I travel to India, get married, while the current filed H1B is still pending, would my spouse be able to get H4 visa? Very good question. I do not know. I do not know the answer to that question. You can certainly try. You can even email the consulate about this situation. Because normally it should be possible. You still have H1 status. You have a timely filed case. You still have approval till 2019. They should be able to give H4 visa till 2019. In the event I'm denied entry into the US when I come back, what are my options? Not very many. Denial can take two forms. One will carry with it 5 years of no return back, unlikely. The second one is just asking you to withdraw your application for admission, which is not that much of a problem. You can always come back with a new visa. It's difficult to answer this question in the abstract. So, how can you come back is a different question than what problem can I have. The problem can only be either they deny you admission or ask you to withdraw your application for admission. If they deny you admission, 5 years bar. If they allow you to withdraw admission, you can come back the very next day. Don't know if I can help you any more than that. Star 5 with a follow-up question. So Nick H1B has another question. If I'm working for employer B, transfer with employer A, then employer B filed my case, I joined them on a receipt, approval is pending. Can I join employer C? Yes, the same law applies. As long as A, B, C, D, you end up with D, you can still join with the receipt. And if your previous I-94 has expired, then as long as A, B, C are approvable, even if they are not approved, they are approvable, you can continue with employer D, and chances are you will get your extension within the United States. Star 5 if you have a follow-up question. Aparjit Sairam works in Morrisville, North Carolina on H1B, more than 1 year, worked for another company for 3 years. H1B started in October 2014. Before that I was on OPT. Green card not yet started. I want to take a break of 6 to 8 months to learn some advanced yoga. You can do that. You don't need to be worried about the lottery system, because once your H1B is approved, you are good for 6 years. You don't have to go through the quota again. So I don't see any problem with this. You may have to get another H1 approval if you are quitting this job. If this job is going to continue even while you are gone, they're not paying you, but you've taken a leave of absence, and they can assure the government that they still have the job open for you. No problem at all. Okay. Star 5 if you have a follow-up question. I'm not sure. Give me 1 second, guys. I'm just renewing I see an error. Okay, it looks like we are okay. I was wondering what happened. We have a lot of people online, but no follow-up questions. Okay. Teja, which is RSU 11. Currently on L1B, I have to leave USA, but I got L1B and I-94 till December 2019. I want to join school. Can I attend classes while change of status is still processing? I think so. I think this is the only exception to the general rule that you cannot. Double check with the designated school official, DSO, in the International Students Office. I think you can join school even while the F1 is pending. If I apply for change of status based upon the current I-20, can I switch universities? I believe so. Can you do it before joining? Don't know. Gonna have to check with the DSO. If my change of status got approved before classes start, can I stay in USA till semester starts? I think there's a limit. So I believe it is 30 days. There must be less than 30 days between the gap between your approval and your class date, something like that. Again, double check with the DSO. They have all this information for you. If your L1B gets terminated, again there's a 30-day period that I'm worried about. And I think this also applies like this. I've seen this happen many times. There's a regulation that covers it. So one example is, let's take your example. So you've got your L1B till the end of June, then they've revoked it. But the classes start in August. Because there's more than 30 days between June and August, I don't think you can stay in USA. That's what I remember of the law. best time to resign my job is probably wait till the change of status is approved, I think. Okay. And then you can quit the L1. Okay, star 5 if you have a follow-up question. Oh, good. I thought my system was not working. Okay. Let's go to Georgia. Georgia, go ahead, please. Then there's another one after that. Okay, Georgia, go ahead. Georgia.
Hi. This is a related question to F1 and student visa.
Sure.
So my wife is on F1 visa and she's on OPT right now, and she wants to travel to India, and the time when she'll be coming back to US on OPT, she'll have only 40 days left. Is it safe to travel?
Is she applying for H1? When is she going? When is she coming back?
She's going on November 28th, coming back on December 15th, and her OPT expires on January 26th.
So what would she do after?
She applied for it.
Oh yeah. What did you say? Yeah. Go ahead.
She's on STEM, so she can do an extension of OPT
Yeah.
for that 17-month period.
I don't see that should be a problem. I think that should be fine. Just make sure that she gets her I-20 endorsed for travel.
Okay.
Okay.
Because we were worried that
No.
if only 40 days are left,
Another thing.
then they will pose a problem.
Another thing. Her total period of absence must not exceed whatever time they allow you to be in non-productive status. I think it's 90 days during 1 year. What is it? OPT for OPT. So as long as her total out of work period doesn't exceed that, that's fine. I don't see any problem with it. Okay?
Thank you, sir.
You're welcome. Okay, I've got 2 more questions related to this, I hope. 3 more. Okay. Then let's go to Illinois. Illinois, go ahead, please. Illinois.
No, sir. I'm Tej. I'm about L1 to F1 status.
Okay, go ahead.
Yeah. Can I attend the? Without leaving the country, can I stay in the United States while applying for a stay?
Yeah, I already answered that question. I said that as long as you meet the other rules, F1 change of status pending allows you to start school as far as I know. Okay.
Okay. Okay, sir. Thank you.
You're welcome. Okay, let's 2 more questions. This one is from California. California, go ahead, please.
Hi, can you hear me?
I can. Yes, ma'am.
Okay, yes, I'm sorry, the system didn't allow me to speak up earlier, but I was following up on the questions the H4 you went through earlier.
Okay.
So when you, I read your article that say J4 dependents can go to school without needing an F1 visa, without needing to change to F1 visa. So when you say my better option in my situation is F1, is that because I only come here for a short visit on the J4?
Oh, you're talking about the the G4. Because see, ma'am,
Yes.
the problem with the G4 visa is there are a couple of issues here. As far as this is, I'm just speaking without researching this issue. This is to the best of my knowledge. So keep that in mind. But the problem with G4 is, unless you are here for a long term, first of all, let us forget about the student visa. Let's say your husband comes with you. He's also on G4. Let's say you come here for 3 months and then you leave. And you're not going to come back for, let's say, 6 months. Can your husband stay back on G4? No. So when the primary applicant is gone, the derivative is not allowed to stay back. Applying the same to your situation, I think that would be the first objection the government would have. That, ma'am, you are on G4, you have left. How can we let your child remain on G4? So I was not sure how you would deal with that. And I think it might be just better to convert to F1 and get the I-20 done and just come back on F1 visa. That way, the child is not dependent upon you.
Thank you.
You're welcome. Good luck.
Thanks.
Okay, and then the last question in this series of questions is from California. Go ahead, please, California.
Rajesh, sir, this is for the earlier question. So, sir, if we change, while the H1 extension is processing and change the client, like we discussed,
Right.
will it reset the clock again to 6 months or 8 months?
If we change the client, reset the clock, what clock are we talking about?
Sir, my I-94 is expiring December, and I'm applying for extension in June.
Okay.
And while it is being processed, the extension is being processed, if I change the client, will it reset the clock again?
But I'm not understanding, what clock are we talking about? Are you talking about the processing time, H1 processing time?
Yes.
Yes. Each one will be a separate application, and each one will begin the clock of the processing time from the date you file that application.
So if I say after 5 months, while this is going on, I change the client B, and again the H1 processing time will reset,
Yes.
and I'll have again like 8 months.
Whatever the time is, whatever the processing time is, will remain the same. Your pending case will not subtract the time from your subsequent case.
Okay, sir. So I can continue to work for the next 8 months.
That's what my belief is. Yes, sir.
Okay, sir.
Okay.
Thank you, sir.
Good luck. Okay, then let's go on to adoption. TQNK. I am naturalized. If I adopt a relative child, let's say adoption completes before the child gets 16, and it's legal in the foreign country, but I don't follow those procedures, and I do 2-year custody. You know what? I don't know the answer to that question. I'll tell you why. If you were on H1 or L1 or even a green card holder, clearly you can do this. Can you do this even as a US citizen? My guess is yes, but this is such an important thing. I would want you to have it researched. I believe, let me tell you what the 2 ways to bring children into the United States are. Children who are not your natural born children. If you're a US citizen, you go through the prescribed USCIS procedures that don't require 2 years of custody requirement. The other method, which is available to everybody, I don't know for sure US citizen, I think it should be, which is available to green card holders, H1, L1, anybody, or even F1, if you want to adopt a child and make them your child under US immigration laws, you have to adopt them before a certain age. I forgot what that age is. 16 sounds right. There are 4 different ages, 14, 16, 18, 21, depending upon what benefit we are talking about. So let's say we get them adopted before a certain age. Adoption is legal in the home country. You are required to have 2-year physical custody of the child. Then, under the definition of Immigration and Nationality Act, that child becomes your child after the 2 years of physical custody. I think it should be available for 2 US citizens also. Now, do I know all the answers off the top of my head? No, but I know the way it goes. So you may want to have this checked out. What is the age for adoption, and whether US citizens can take physical custody and then they become your child for USCIS purposes. I think all of this is possible. And I also want to point one thing more out. Let me try to remember. I had this thought and I think it slipped my mind. You've got a child, you've got them adopted, you've got the physical custody done. Oh yeah, there are Hague Convention countries and there are non-Hague Convention countries. The procedures for adoption may be different in different countries. So just keep that in mind. There are so many variations. to this theme, it is difficult to give you a blanket answer. But I hope I've given you enough information to get started. Star 5 if you have a follow-up question. Okay, let's take that. This one is from California. California, go ahead, please.
Okay, so the age limit that you are talking about, let's say the adoption needs to be before the 16 and after the 2 years custody, the age limit to submit change of status or family sponsorship is 21. Is that
Yes, yes. A person remains a child for benefits purposes, which means green card benefits, remains a child until they are single and 21. Okay?
Thank you.
You're welcome. Good luck. Then we've got this question about getting paid on 1099 while collecting unemployment. I'm not sure that sounds right. Something sounds hinky about it. 1 second. I have a question from Pennsylvania. Let's take that. Pennsylvania, go ahead, please.
Hi Rajiv, same question. I just want to make sure for the adoption. I think you said like all the H1 or in any status they can go for
Yes.
adoption and
Yes.
2-year custody. Is that correct?
Yes. Oh, by the way, another idea came to my mind. Ma'am, I hope you are still here. There's a big question about what physical custody means. Okay. Do I have to move to India to take care of the child? Can I bring the child here on some kind of a visa, like a tourist visa or a student visa? While they go to school, I'm in their custody. Or what if the child resides with my parents in India and I call all the shots? All of this needs to be researched a little bit. I'm not sure how far the definition of custody can extend. Of course, easy answer is one of you moves to India and takes custody. But I think all these variations should be factored in. Go ahead with your question. Sorry, this thought came to my mind. I didn't want to lose it. Go ahead.
My current situation is I am in H1 and I have 140 approved.
Okay.
At this situation, can I adapt any like US born, adoption? Is that possible?
Oh, yes. Adopting a US child, as long as the state law where you are living allows you to do so, is no problem. The only question is, does the state law allow you to adopt when you are a non-immigrant? Of course, once you become a green card holder, you should be allowed. But can you do it when you are a non-immigrant? I don't know the answer to that question. I would say that depends upon the state law. Okay?
All right, Raji. Thank you very much.
You're welcome. Okay. So, going back to this question, can I get paid on 1099 while collecting unemployment? There's an immigration perspective that I can try to work on, but I don't understand. I think there could be a problem with is this fraud? Because I'm telling the government I don't have a job, so give me unemployment benefits. I don't know the answer to this question, sir, but it's certainly, or ma'am, it certainly looks like a little bit of a hinky situation. I'll be uncomfortable with this. Have it very properly researched. I don't know the answer to this question. I don't think you can. And the last question today is, any follow-ups on this question about unemployment? Okay. Last question today is from Contact.js. I'm currently working on H1B as a contractor at a client company. My company got acquired. My client company got acquired. Oh, that shouldn't be any problem. Because, see, if your employer got acquired, that would be a different situation. If the client company gets acquired and your job remains the same, I don't see any problem. Star 5 if you have a follow-up question. Star 5. Okay, folks. Thank you, everyone. We went a few minutes over, about 15 minutes, but I, as always, feel very privileged to be able to talk with all of you. I'll speak with you again in 2 weeks. Thank you all for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away, and post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.